Good morning, and on behalf of the Law Society of Upper Canada, welcome to today's program, the agenda for which is at the front of your materials. I'm Paul Truster, Program Lawyer for the Department of Continuing Legal Education. Not all our speakers are here yet, but I'd nonetheless like to seize this opportunity to thank them all for the time and effort that they've put into this program. CLE is a nonprofit arm of the Law Society, and of course we're completely dependent upon the volunteer efforts of our faculty, and deeply grateful for it, and I thank you all. Now it's my pleasure to introduce the chair of today's proceedings, Howard Levitt. You'll find his biography along with biographies of the other faculty inside the binder. I'll just point out, after articling with McCarthy and McCarthy, Mr. Levitt joined Imperial Oil to conduct all labor law matters under provincial and federal jurisdictions for that company. Now, as the principal in Howard Levitt and Associates, a full-service human resources law firm, Mr. Levitt has limited his practice exclusively to the area of labor and employment law. He's conducted labor law seminars for the Canadian Manufacturers Association, personnel associations of Toronto and Hamilton, and other management groups across Canada, including, I understand, a twice-yearly seminar on wrongful dismissal. In addition, he's also a columnist for the Toronto Star and has appeared on many television shows, including The Journal, Business World, and W5, discussing the issues involved in wrongful dismissal. He's also been interviewed, and his comments and opinions have appeared in many publications, including the Financial Post, Financial Times, Canadian Business, Maclean's, Globe and Mail, the Toronto Star, New York Times, and Wall Street Journal. He's the author of The Law of Dismissal in Canada, the second edition of which has just appeared, and editor-in-chief of the Dismissal and Employment Law Digest, which discusses new developments in law and publishes monthly summaries of every wrongful dismissal case and labor law code decision in Canada. Please join me in welcoming Howard Levitt. Thank you.
Thank you. It has only been some 15 years since the case law effectively set a 6-month limitation on severance awards, and social mores were such that suing one's employer was almost unheard of. And even up to 3 years ago, employment law practice consisted of little more than advising one's client as to whether or not there was cause, and if so, or if not, how much severance one was entitled to. That is no longer the case. The law has evolved to permeate all aspects of the employment relationship and to create vestigial rights and entitlements. Increasingly tortious doctrines are entering the law of employment. Issues such as negligent referencing, workplace harassment, and negligent misrepresentation for unkept promises, both at the commencement of the employment relationship and during its currency, are arising as legal issues. With the Machtender and Hodge decision, the question arises at least as to whether employers have a fiduciary duty to their employees, and if so, what obligations flow from that. Similarly, the courts are finding new obligations on managers and individual employees, flowing both from statute and common law. Conversely, the courts are examining the obligations of employees to their employers and what suits for damages may arise from a breach of those obligations. Within more traditional wrongful dismissal law, courts are taking a more contextual analysis of cause, looking at public policy and determining notice periods, and at least within Ontario, reassessing their previous analysis of how to assess damages. Constructive dismissal, virtually an inaccessible right for employees as recently as a year and a half ago, has recently substantially broadened, at least in my view, in its ambit. Increasing awareness of human rights issues and employment law rights are impacting on the advice which we have to counsel our clients concerning. I'm delighted to have the quality of faculty that are assembled today, and thank you for attending. Most, if not all of you, attending today are doing so as a result of the participation of the first two panelists. Madam Justice McLachlin was born in Pincher Creek, Alberta. She received her Master's in Philosophy and Law degrees at the University of Alberta in 1968 and her LLD from the University of British Columbia in 1990. She was called to the bar of Alberta in 1969 and of British Columbia in 1971. She practiced law for 3 years in Edmonton, 2 years in Fort St. John, British Columbia, and 3 years in Vancouver. In her last year of practice in Vancouver, she became a lecturer at the University of British Columbia, ultimately becoming associate professor and tenured professor at that law school. She's the author of numerous publications and was appointed to the Vancouver County Court in April 19, 1981. Following that, her rise was meteoric. Appointed to the Supreme Court of British Columbia less than 5 months later, the Court of Appeal of British Columbia only 4 years after that, and Chief Justice of the British Columbia Supreme Court only 3 years after that. Only 6 months after that, on March 30th, 1989, she was appointed to the Supreme Court of Canada. I asked her to attend today because during argument of the Machtender case, no other member of the court, and from my perspective, radiated as much interest, intensity, and enthusiasm for the subject matter. I wasn't surprised when she wrote her complex, thoughtful, and compelling concurring decision. Mr. Justice Finlayson has, in my view, had more impact on the development of employment law in Ontario than any other judge. He was involved in the judgments of the Court of Appeal in many cases, including and not limited to Queen and Cognos, Helbig and Oxford Warehousing, McKinney versus the University of Guelph, Craig v. Healthcare Services Upjohn, Hollyburton versus the town of Markham, Donaldson v. Philippine Airlines, and Lindenberger versus United Church of Canada. He also wrote a strong dissent in McKay and Camco, the analysis of which appears to be affirmed, from my perspective in any event, in the Supreme Court of Canada's Raich v. Bloomer decision. Obtaining his Bachelor of Arts in 1949 at the University of Toronto, he was called to the bar in 1953 and obtained his Queen's Counsel in 1964. He received his Doctor of Law in 1981 and was appointed a judge at the Supreme Court of Ontario and a member of the Court of Appeal on December 4th, 1984. In addition to membership in the Law Society of Upper Canada, Mr. Justice Finlayson is a member of the bars of Newfoundland and Labrador, Alberta, Northwest Territories, and the Yukon. He became a bencher of the Law Society in 1970, chairman of the Legal Education Committee in 1975, was elected treasurer in 1979, and re-elected in 1980. It will be no surprise to those who knew him when he practiced, Mr. Justice Finlayson's contributions to this community have been prodigious. He was a member of the Canadian Bar Association since 1951, held various offices, and was chairman of various committees including membership, continuing legal education, administration of the courts, and served on national council on a number of special national committees, such as the Special Committee on the Constitution. At the time of his appointment to the bench, he was a member of the Special Committee on Ethics. He was an original member of the Advocate Society and served as director. He was also a member of the Medical Legal Society, the Toronto's Lawyers Club, and the County of York Law Association. I know it to be the case from discussions that many employment lawyers who've come here today have done so largely because of the strong imprint that Mr. Justice Finlayson has made and will continue to make in this area of the law. I'd like you to welcome both of them.
Well, let me begin by saying how pleased, can everyone hear? How pleased I am to be here this morning. As Mr. Levitt has mentioned, employment law has always interested me. I've sometimes reflected why. I didn't practice in this area when I was a lawyer. I became interested as a trial judge. It seemed to me that the problems we were facing were much more complex than the doctrine that was there to solve them. In other words, we had the contract mold, but the problems didn't seem to be, in many cases, capable of resolution within that traditional mold. So, from an academic or intellectual point of view, I became interested in this area of the law because I saw that it was, I perceived, or I guessed in any event, that it would be an area of the law which would be developing rapidly, where doctrine would have to move to catch up with changing social mores and the realities of our new workplace. And the other reason I was interested in it was because it involves, in every case, a very real human problem, a very real social problem. This area of the law matters a great deal, and it matters to not only people who are running our companies and our businesses, but to the individuals employed and their families. That said, I have never found the area simple. And today, in the past few days, when we've been discussing amongst ourselves as panelists what we would do, I reflected on what I could usefully add. Justice Finlayson will be giving you a detailed and very comprehensive look at some of the recent developments in this area of employment law and wrongful dismissal. And Mr. Levitt will be doing much the same and talking about practical matters of how you proceed with an action through court. And so I thought, well, what can I usefully add? And I thought that perhaps the one thing I could do usefully would be to bring you a slightly different perspective and a simple message, really, which is, think of wrongful dismissal or employment law not as a category which has its own rules and so on and so forth, but think of it as an aspect of our common law, civil law, as a whole. And if you do so, I think you will see that there are a vast variety of approaches, remedies, and so on, which some of them are being developed, some of them have been used to some extent, and some of them have yet to be developed. And this is where I see the area for growth and lying in this particular area of contract law. One of the things that strikes us on the Supreme Court of Canada is that often when we get appeals in a particular area, let's say family law or something like that, stay away from present subjects, we find that counsel can be so imbued in the particular cases that apply to that particular area of the law that they don't see the relationship between the things they're urging or asking us to reject and the rest of the law, the general principles of contract, tort, equity, and so on. And so they argue from too narrow a perspective, and they often don't argue as well as they could, because certainly at our level, and I think at lower levels too, the courts are concerned not only with the particular case in the particular area, but they're concerned to develop a jurisprudence that will have general application as well as providing the specific rules that are required in the specific areas. So the thing I'd like to do today is concentrate a little bit, not only on the standard doctrine of employment law, but suggest to you some of the areas where other doctrines of general law are supplementing that. The starting point, of course, in any discussion of employment law must be the contract, because the law of wrongful dismissal is fundamentally law of contract. There is a contract between the employer and the employee. But this doesn't mean that new ideas can't be introduced. Contract itself is a flexible enough instrument to accommodate a variety of considerations, and as I've already indicated, it can be supplemented by other causes of action. But returning to the contract, and specifically the situation which confronts us most often in employment law, the question of wrongful dismissal, and the correlative question of the amount of notice to which an employee is entitled. the basic rule is that the contract provides the amount of notice. Well, as we all know, the contract may say nothing on the matter. And then the courts use the device of implied terms to come up with the amount of reasonable notice. Now, I think it's very important to realize that an implied term is not a single thing that is always the same in every case. The so-called doctrine of implied terms is itself something of some complexity, and a lot of the confusion that arises in this area is that people try to apply one concept of an implied term to a problem when they should be looking at another concept of an implied term. And there's a very good analysis of the three different kinds of implied terms in Treitel's Law of Contract, the 8th edition. And our court, in a judgment of Justice Ledane some years ago, picked up on this. And basically, Treitel says there are three kinds of implied terms. There are terms implied as a matter of fact, and you will all remember these from your first-year contracts court when you read Lord Justice Scrutton's judgment, and the test was, it's obvious that had the parties directed their mind to this, they would have included this term in the peculiar circumstances of this case. So that's a situation where the parties just forgot to put it in. And that's what, at least I, when I took contracts in first-year law, came to think of as the implied term. Doesn't make much sense in an employment law context in many cases, because the parties usually don't put it in because they don't know what to put in or whatever, but not simply because they forgot about it. And moreover, it doesn't seem very obvious from the circumstances often what they would have said at that time had they put their minds to it. So that's the first kind of implied term. The second kind of implied term is an implied term by law. And here we have to recognize that the courts aren't going subjectively into the parties' minds the way they did on Lord Scrutton's test in the first category. They are simply saying there's a lacuna here in the contract, and to do justice, we have to fill it in, and so we will. And that's the implied term by law. And that's where I think most of the implied terms we see in the wrongful dismissal situation fall. They fall into that category. The court's saying, we don't know what these people would have said had they put their minds to it, and there's no point speculating about it. The question is, what is reasonable notice in these circumstances? An objective test which has nothing to do with the subjective contractual intention when you think about it conceptually. So the courts are imposing a duty through the doctrine of implied terms. And then there's a third kind of implied term which sometimes may impinge on employment situations, which is implied by customer usage of the trade, where there's a customary practice. But I think for the most part, when we talk about implied terms, we're talking about the second category. And we might as well be honest and say what we're doing is not trying to get back into the minds of the parties at the time. In most cases, we're trying to decide what is reasonable. So if you go into a case like this and you start arguing to the judge, well, if they'd put their mind to it, they would have said this and would have said that, the judge's eyes are probably going to glaze over, because she realizes or he realizes that the real problem is what is reasonable in these circumstances. For example, having regard to the length of notice, length of service, a factor which those people couldn't possibly have known at the beginning in most cases. So be aware of what sort of implied terms you're using when you're using it. That's the general framework, the contractual framework on which, of course, all wrongful dismissal actions stand. Sometimes contracts will provide for, very often, they provide for length of notice, and you don't have to resort to implied term. Here there may be problems, however. The length of notice may be below the statutory minimum, for example, as it was in the Machtender case. And then, as has been ruled, the statutory minimum goes, and the court is in a situation where you imply a term, or at least that is the way I saw the problem. But this is the resolution in the contractual framework. And most cases, I believe, will continue to be resolved within that contractual framework. However, we must not be blind to the fact that there may be situations from time to time which require us, in an attempt at you as lawyers to find the just solution to a problem, we as judges in the same pursuit, to look at other doctrines than the pure black letter contract law and see whether there is help in other areas of the law for in attempting to resolve the particular problem we have before us. And I'd like to mention a few of those, which are increasingly being argued by innovative counsel and increasingly, I think, accepted by the courts, where the fact situation is right, where justice so requires. And by way of background, I'd like to just mention something of which you're probably all aware. There's been a lot of writing and talk in recent years about the new morality of the civil law of contract and perhaps tort. But we see, according to some theorists at least, a departure from the old laissez-faire black letter contract principle, every person has to look out for themselves, and perhaps a move toward doctrines which insist on standards of fairness in commercial dealings as judged by what reasonable, conscientious, honest people would expect. And we see this in many cases, the Lac Minerals case, for example, in particular, Justice Laforet's judgment in a completely different area than this, but introduced this idea of morality in the law, and that development has manifested itself in a number of areas, which I think can apply to employment law. The doctrine of unconscionable transactions. A contract, now this isn't going to be the normal case, but it's something to have in your arsenal. A contract can be so unfair that it's unconscionable. A situation perhaps where one party is taking advantage of another party. That can happen in the formation process of an employment contract. And the courts could grant relief against such a contract no matter how ironclad its guarantee or its 3-month notice provision was or anything else. The courts could, in the appropriate case, use that doctrine to say, this whole transaction was unconscionable from the beginning and we will set it aside. The doctrine of fraud or the action of fraud or deceit is always there. It's an old action. Don't forget about it. It's been there for many, many years. It can, in some circumstances, assist. And I can't go into all the law today, but it's easier to succeed in a deceit action nowadays than it once was thought. It was once considered extremely difficult. There were extremely high burdens of proof. You had to establish the deceit or the fraud to a much higher degree than you would negligence. That, to my perception at least, has been relaxed by a number of cases in the civil area, and so it's now easier than it was. Then there's negligent misrepresentation. This was considered in the Cognos case, in which the Ontario Court of Appeal did not apply that doctrine, but nevertheless, in the appropriate case, it may afford a remedy, even perhaps where the contract has a stipulation as to term for notice. If there has been a misrepresentation that goes to perhaps something other than the actual notice, but the stability of the business or the type of work or something like that, then there may be relief there to an employee who went into an employment situation with an expectation of certain things on the basis of representations and then found that those representations weren't there. So that's another doctrine. One of the problems in any contract situation, and it seems to be particularly problematic in the area of employment law, is the problem of adjusting to new circumstances over the years. We have one contract, and it's supposed to last sometimes for a whole career. And that is a big problem. It's a big problem for any contract situation. And so we see in contract law a whole series of doctrines and so on, which techniques which are aimed at solving this problem, that how do you adjust a contract to changing circumstances? Now, that's particularly of concern in the employment context. But the law of contract, when people are drafting commercial contracts, what do they do about these things? Well, they sometimes make it a short-term contract, i.e., this contract will be 4 years and then we renew it so we can think about the terms again. That's one possibility. Or they can say, well, we put in an agreement to agree clause. But none of these techniques, to my view anyway, work very well. And so it's a basic problem we have in contract law that we're going to run into cases where circumstances have changed so the original contract doesn't seem to fit. And what do you do in that circumstance? Well, there is a doctrine in contract law, and it's quasi-contract perhaps to some extent, but I think it could be used. It's been used in commercial cases where that sort of thing happens, and that's the doctrine of new contract. In other words, you start off with one employment document, and that's your employment contract. But perhaps the argument can be made that over the years, as the relationship changed, as the circumstances changed, perhaps as the employee assumed many new responsibilities or was asked to do different things, the nature of the employment changed, that in effect this contract changed. So it's a difficult thing to do, to show, but certainly there are cases where the new contract doctrine, particularly in the United States, has been successful. And that is one idea to consider when you're faced with the problem, which often arises of a contract that was signed way back when and doesn't seem to fit the reality of the situation as it has evolved. One of the most interesting developments, which I'd like to discuss with you a little bit, which I think could impact on employment law, and its ramifications are still uncertain. Please don't take me as saying that the Supreme Court of Canada advocates this as a general rule of the common law, but I think it's very interesting, and I'd like to, if you're not aware of these developments, and you may be, share them with you. And that is the idea that's emerging in the law of contract area of the duty to bargain in good faith and the duty to discharge one's contractual obligations in good faith. Now, this has been recognized in the United States for some time. The American Law Institute's second restatement on contract says, and it's section 205 if you want to look at it, every contract imposes upon each party a duty of good faith and fair dealing in its performance and enforcement. Now think about that. That's saying not only the black letter of the law, but in the formation of the contract as well as its performance, which can go throughout the whole employment relationship, a duty of good faith. Now, I'm not saying that's a fiduciary duty. That may be another step. But there does seem to be, at least in the American law, a recognition of some sort of duty of good faith. Well, this seems to be emerging now in Canadian law as well. And we saw an early sign of it in Justice Lafort's decision in the Lac Minerals case, to which I have already referred. And of course, that was not the majority decision, but it has been an extremely influential decision. And there, Justice Lafort states that the institution of bargaining in good faith, he was talking about bargaining, formation, is one that is worthy of legal protection in those circumstances where that protection accords with the expectation of the parties. So he's saying it's not an obligation that is out there in abstract, but if it's one that accords with the expectation of the parties, which is, I suppose, the usual thing in an employment situation, the law might well protect it. Well, recently, the Supreme Court of Canada, in a civil law case from Quebec, and I stress that because that means it is not necessarily going to apply in the common law area, but it is nevertheless significant, has recognized a duty to contract and discharge the contract in good faith. And the case is the Houle case, Banque Nationale du Canada, Houle et al., and it's 1991. I'm sorry, I've got the wrong site. I do these things that I always chastise counsel for. 1990, I think. 3 Supreme Court reports, 122. Justice Leroux wrote the decision. And it's not an employment situation. But writing for the court, and I won't go into the details because it's very complex financial bank sort of situation, she read into the parties' contract an implied qualification of the bank's express rights. The bank had said, we have the right to do A, B, and C. She said, no, you don't. There's an implied qualification, and the reason there's an implied qualification is the duty to bargain in and execute and discharge your obligations in good faith. And she says, there can no longer be debate in Quebec law that the less stringent standard of the reasonable exercise of a right, the conduct of the prudent and reasonable individual, as opposed to the more stringent test of malice and absence of good faith, can ground liability resulting from an abuse of contractual rights. In other words, there seems to be a conception of a doctrine of abuse of contractual rights. Moreover, every contract contains an implicit obligation on the parties to the contract to exercise their rights in accordance with the rules of equity and fair play. Now that sounds very like the restatement in the United States. And I underline again, it's only a statement of the law for Quebec, but it may have ramifications elsewhere. We'll have to wait and see. It's interesting to note that only in 1987, Justice Leroux had taken the same position on the Court of Appeal in Quebec, but she'd been dissenting. So the doctrine has advanced in Quebec. There is a case in the common law jurisdictions that applies the same doctrine, and that's Gateway Realty Limited versus Arton Holdings, and it's at 1991, if my cite's correct, Nova Scotia Journal, I believe, NSJ in any event, number 362, and it's a Supreme Court decision. And in that case, Justice Kelly relied on a general duty of good faith and found a fundamental breach of a lease contract justifying its termination because of an assignment of a lease to a competitor amounting to bad faith. And he relied on American as well as Canadian authorities, and he said the insistence on a good faith requirement in discretionary conduct in contractual formation, performance, and enforcement is only the fulfillment of the obligation of the court to do justice in the resolution of disputes between contending parties. Now, as I say, that's as far as my research indicates that doctrine of good faith has got in the common law jurisdictions of Canada. But I mention it to you because I think it's something we'll be hearing more of, and it will probably ultimately be coming before our court and other courts for further consideration. And I mention it because I think, given that employment laws fundamentally question a contract, this doctrine, should it become widely available, could have an influence on employment situations where often duties of good faith and fair dealing and so on seem to play a major role. Well, I've touched on a number of areas where I think the general law of contract and the law related to contract, which we find in the equity area, is relevant to wrongful dismissal and employment law and may be of assistance. And I would urge you once again, when you're considering these problems, don't just, much as Mr. Levitt's book is extremely useful, don't confine yourself to wrongful dismissal texts and cases. Look to the broader law and see what is there that can help you in an imaginative way to meet the particular problem you're faced with. Another area which I'll briefly touch on, and very briefly, because Justice Finlayson is going to cover this in much greater depth, where there is room for development is in the area of just cause. And I think courts are taking a much more, and counsel as well, sophisticated look at what's involved there and a more fact-oriented look. And seeing that many things other than the failure to actually type in those words or be at your desk can, in appropriate cases, amount to just cause. And we have to be a little more flexible when we look at it. For example, sexual harassment is figured as just cause, as has an employee's general unsuitability for the position. And it's now, I think, generally accepted that certain positions carry with them even an expectation and a requirement, if you wish, that one's personal life meet a certain standard. That applies to judges, and as we see in the press recently, cabinet ministers. It might apply to other people. Think about daycare workers or a social worker, or people who, if you're trusting, I know as a mother, if you entrust your little child to someone, you're thinking about what kind of a person they are, aren't you? Church workers, that sort of thing, and there may be many others where there are expectations and requirements of employment which go beyond the actual workplace. There may be representative factors. The demeanor of a corporate executive might have to reflect a certain image for him or her to be suitable for the position. So I'm going to terminate there. I've taken as much time as I should. I would just like to encourage you again to think of the law of wrongful dismissal as a growing, developing area of the law, and one in which we as counsel and we in the courts have to be flexible in order to meet the changes which we are seeing in the workplace and in the expectations of society. Thank you very much.
Well, thank you, Mr. Levitt, for your very generous introduction. I've listened with great interest to Madam Justice McLachlin's comments, and I propose to expand on her observations by discussing the practical effect of some of the more recent decisions in the areas of wrongful dismissal, interpretation of contracts, and also to consider some changes in the law with respect to constructive dismissal.
I'm not sure if the mic's on.
Sorry?
I'm not sure if the mic is on.
Can you hear me? Yeah, thank you. Not very well. All right. While the employment relationship is fundamentally a matter of contract between employer and employee, the law with respect to it has been in a continual process of evolution, and in that sense is a reflection of the common law. When I attended law school, this branch of the law was still referred to as the law of master and servant, with the implication that the relationship imposed a status on the servant and that he or she was a form of property of the master. The emphasis then was upon the duties of the servant rather than the obligations of the master. There have been significant social and economic changes since then, and we're now operating in a completely different milieu. Not only are employees not looked upon as servants, but the law accords them a recognition as employees that goes beyond strict contractual accountability. The emphasis today is upon the responsibility of the employer operating within the confines of the contract of employment to provide an acceptable workplace. This is just not a workplace that is hazard-free. It is a workplace that is concordant with the carrying out of the employee's duties, one that is acceptable in terms of health and safety, is environmentally friendly, and for want of a more descriptive word, is politically correct. For that last term, I'm referencing human rights legislation and the requirement that not only in the hiring process, but in the ongoing employment relationship, an employee is to be free from any form of discrimination relating to race, religion, sex, or other prohibited grounds of discrimination. The employer can be required to accommodate the particular employee so as to remove or to lessen the extent to which he or she may be disadvantaged by the requirements of the job description. From the perspective of management, this may simply seem to create additional burdens, but what I have said does nothing more than recognize the reality of the workplace and that it has changed from a job-oriented environment to one that reflects certain social and moral imperatives. It is now accepted that persons who are physically challenged should be entitled to make their contribution to the workforce. Job descriptions that traditionally have restricted applicants to big men because of the requirement of size and strength are modified now to permit the effective employment of women or men of more limited physical capabilities. Working hours can be adjusted to accommodate days of religious observance by non-Christian denominations. The law recognizes it as the responsibility of management to introduce policies into their business that foster this modern concept of a workplace environment and to insist upon their implementation by all supervisory personnel. On the other side of the coin, the nature of business itself has changed. Today, the business community is striving to adjust to the pressures of international forces arising out of free trade, to a global recession, and to international environmental concerns. Business has just survived the 1980s with its decade of mergers and acquisitions and is now making major adjustments in recessionary times through layoffs and plant shutdowns. The law must recognize that business requires more flexibility in restructuring the workplace and reassessing and reassigning job responsibilities. We are also importing new management concepts, such as the Japanese practice of using groups of employees with interrelated skills that work as teams. This mandates fundamental changes from the linear management chain of command. I think it is apparent that the law now takes a broader view of management rights, which are necessary to implement new social values and adjust to the new business climate. The areas touched upon below reflect this change of attitude. Dealing with just cause. There is an apparent trend in the case law towards a broader application of just cause as a response to claims for wrongful dismissal. One example of this apparent trend is the increasing willingness on the part of courts to recognize the existence of contemporary standards in the workplace and an implied duty on employees to conform to such standards. These standards reflect the changes in social and business attitudes that I have referred to above. The courts are prepared to accept that management can take disciplinary action to ensure that these standards are maintained. Now, Madam Justice McLachlin gave an example of sexual harassment, which of course can be a ground for dismissal. It reflects the unacceptability of sexual harassment in modern society. The standard that embraces a workplace environment that is free of sexual harassment is a general one, which applies to all places of work. But these new standards and the implied duties they create are not necessarily applicable to all places of work. Some may be common, such as the ability to work harmoniously and productively with other employees, which has grown out of changes in work distribution in order to emphasize teamwork. And I reference Finico versus McDonnell Douglas Canada Limited, which is an Ontario High Court judgment, and Perham versus the Canada Trust Company, which is the British Columbia Supreme Court of Canada. Others may be general within a particular industry. For example, in Esri and John Leckie and Company, 60 Newfoundland and Prince Edward Island reports, the Supreme Court of Prince Edward Island found that a hairstylist's untidy appearance, his inability to work as part of a team, and his poor attitude towards clients justified dismissal in a service business involving close contact with customers. Finally, in some cases, employees will be expected to conform to the standards which are specific to the company or even the position of the employee. In Bell versus Cessna Aircraft Company, another British Columbia case, an employee who believed that his supervisors were conspiring to have him dismissed reacted by contacting the executive of the United States office, which is responsible for Canadian operations. The British Columbia Court of Appeal affirmed in principle the Supreme Court's holding that an employer is justified in dismissing an employee for ignoring the established chain of command where a company has a rigid hierarchical structure. Now, by recognizing the complexity of determining a person's suitability for a particular position of employment, the concept of just cause provides a more meaningful defense to a claim for wrongful dismissal. However, in making the law more dependent on the facts of a particular case, this development places an onus on lawyers involved in such cases to present the relevant facts. For example, in a case such as Bell and Cessna Aircraft, the success or failure of a defense of just cause would depend on the presentation of evidence regarding the particularly rigid hierarchical structure of that company. A lawyer representing the dismissed employees would need to know the company structure, its practices, policies, and industrial relations to show that by bypassing middle management, he would undermine the smooth operation of the company. Where the cause of dismissal arises out of the implied requirement of a particular employment position, evidence regarding the position itself would be necessary. In Cardenas versus Canada Dry Limited, the Ontario District Court held that a laborer's repeated tardiness justified dismissal because he worked in a production department which was organized in such a way that it was essential that workers started on time. In some cases, the implied duty may not relate to the day-to-day work task of a particular position. In Green and Confederation Life Insurance Company, the Ontario Supreme Court held that a senior employee's dismissal was justified when his ambition became counterproductive to the smooth management of the company. In that case, the employee attempted to blackmail the retiring head of the legal department into appointing him to the vacant position and to coerce junior lawyers into supporting the appointment. Now, while such conduct can easily be regarded as providing grounds for dismissal, in some cases there will be a question as to whether an employee's conduct warrants dismissal. For example, where an employee is dismissed because of his conduct or demeanor in private life, it will be necessary to show exactly how such conduct adversely affects the image of the employer so as to justify his dismissal. Final issue which may be of concern to lawyers practicing in the area is that of notice. As the courts broaden the defense of just cause by examining it within the context of a specific company or a specific department or even a specific position of employment, the imposition of a duty may become problematic as an employee may not realize the existence of the duty. One solution might be to use the standard of a reasonable employee to determine whether the employee should have realized that his behavior would not conform to the contemporary standards of his workplace. Alternatively, an employer seeking to justify dismissal might rely on the seriousness of the breach of the implied duty as rendering unnecessary any warning. Now, on the constructive dismissal, while there's been a broadening of the application of just cause, there appears to have been a trend towards a limitation of the availability of constructive dismissal. In considering the issues of constructive dismissal, the relevant question is, does the employer's direction to the employee amount to repudiation of the employer of that contract? And my reference there is to Longman and the Federal Business Development Bank, a decision of the British Columbia Supreme Court. In answering the question, a court must determine if the changes were contemplated by the contract having regard to its express and implied terms. If the changes represent a breach of the contract, the court must determine if they are a fundamental breach of the contract. Both of these determinations are questions of fact which have been considered very carefully by the facts. The courts have made it clear that not every change will give rise to a claim for constructive dismissal. In Smith versus Viking Helicopters Limited, the Court of Appeal for this province held that an employer's decision to move its operations and the plaintiff's employee from one city to another did not constitute constructive dismissal. A demotion did not establish a constructive dismissal in Reber versus Lloyd Bank Limited of Canada, a decision of the British Columbia Court of Appeal. In that case, the court noted that the plaintiff had accepted employment at a low level of the bank with the opportunity of promotion. The court further noted that the plaintiff had been assured of no particular position and that the employer had maintained the right to require him to transfer to different cities or countries. There was no implied term that every transfer would be a promotion. Reber and Lloyd's Bank reveals how the courts take into account the specific circumstances surrounding a particular employment position. Another example is Orth versus McDonald Dittweiler and Associates, another decision of the British Columbia Court of Appeal, where following a corporate reorganization, an employee accepted a position as manager of technical resources to be at the same level as his two peers who had been promoted. The employee became dissatisfied with the new position because it did not engage his technical and marketing skills and sued for constructive dismissal. In dismissing the claim, the court held that there was no term in the employment contract ensuring that the plaintiff's new position would have the same combination of duties and responsibilities as the previous one. On the contrary, the court found that the job description itself indicated changes. Courts have also had regard to the circumstances of a particular company. In Jarvis versus Raytheon, Canada, decision of the Ontario Court General Division, the court, noting that the company's products would change as a result of scientific advances, found that there was an implied term in the contract that the company would reorganize from time to time to remain competitive. These decisions also reflect a more general recognition on the part of the courts of the need for employers to have a degree of flexibility to reorganize their affairs. Refer to Canadian Bechtel and Mollenkoff, decision of the Ontario Court of Appeal, and Gillespie and Ontario Motor League Toronto Club, decision of the Ontario High Court. The need to be able to reorganize is particularly necessary in the face of dislocations in the economy. There is no suggestion that economic or other business reasons justify summary dismissal. However, in considering whether a given change the repudiation of contract, the court will consider the economic facts were appropriate. In Lesick versus British Columbia Forest Products, another decision of the British Columbia Court of Appeal, where an employee's position was changed though the salary remained the same, Mr. Justice Taggart specifically held that the trial judge had not given sufficient weight to the fact that the employer was compelled by economic circumstances to change the plaintiff's position from product engineer to plant engineer. By examining all the circumstances surrounding a change, the courts are better able to determine if a given change of a particular position in the company represents a repudiation of the contract involved. On reasonable notice, this is another area which involves situations where there is no just cause for dismissal. The issue in such cases is the amount of notice. Machtender versus Hodge is a recent decision of the Supreme Court of Canada in which the issue concerning the appropriate amount of notice to grant when the contract clause violates the statutory minimum. In that case, the appellants had been hired by the respondent company in 1978 and fired without cause in 1985. Both the appellants had signed contracts of employment in January 1985, which provided for 2 weeks of notice and no notice respectively. Because the Employment Standard Act of Ontario requires that people who are employed between 5 and 10 years entitled to a minimum notice of a month, the contract clauses were held to be null and void. At trial, Mr. Justice Hollingworth ordered reasonable notice under the common law of 7.5 and 7 months respectively. The Court of Appeal held that while the contract clause was null and void, it provided evidence of the party's intention to give the legal minimum notice. The Supreme Court of Canada allowed the appeal, holding that the contract clause was null and void for all purposes and that reasonable notice should be implied. Now, in view of this decision, employers who want their employment contracts to govern the amount of notice that workers can claim must pay particular attention to ensure that the contracts properly reflect the state of any applicable legislation. While such advice may seem obvious, it may prove in practice, it may prove difficult to adopt. The problem with drafting contracts of employment is that they do not involve a one-shot transaction. On the contrary, such contracts must regulate a long-term relationship in which the obligations of the parties change as the relationship evolves. The problem of stale-dated contracts was addressed in Wallace versus Toronto Dominion Bank, a decision of our Court of Appeal. In that case, as you may recall, the employee had signed an employment contract in 1971 at the end of his 3-month probationary period. The contract provided that the bank could terminate the worker's employment on 1 month's notice. The employee sued for wrongful dismissal when he was constructively dismissed after 8 years. The trial judge held that the contract was unenforceable on grounds of unconscionability and awarded damage based on reasonable notice of 1 year. The Court of Appeal overturned the trial decision, holding that there was no basis for a finding of unconscionability in that case. In making this decision, the court took into account the fact that there was no evidence that the employee did not understand and accept the terms of the contract at the time of signing. The court noted that a staff declaration and personnel manual made clear that the termination provision continued to apply to the employee. The court further noted that the employee's position on leaving was much the same as it had been when the parties agreed to the contract. The decision acknowledges the usefulness of a doctrine of unconscionability to prevent the enforcement of an old contract where the parties could never have intended to apply. However, it recognizes that the parties to an employment contract will not wish to constantly negotiate a new contract. Consequently, it requires an examination into the circumstances surrounding the creation of the contract and the effect of enforcing the contract to ensure that a finding of unconscionability is justified. Another problem in trying to interpret an employment contract concerns the changes that occur between the time of the preliminary negotiations and that of the signing of the contract. In one instance, courts have had to respond to the claim of a negligent representation where an employer suggested in an interview, erroneously as it turned out, that an employment position had a degree of permanence, and that is the Queen and Cognus, a decision of the Ontario Court of Appeal, which I understand has now been argued in the Supreme Court of Canada, so we'll be hearing more on this subject in the near future. But our court, in denying the claim of negligent misrepresentation, noted two different concerns with respect to such claims. The first is that they imply the existence of a quasi-fiduciary obligation on employers towards employment seekers when there is some question as to whether such an obligation exists once the employment relationship is established. The second concern is that such claims serve to undermine the certainty created by the clear words of a contract. This is not to suggest that such claims would never succeed, but rather that they will be approached with caution. Now, in conclusion, I'd merely like to say that the developments in the law of wrongful dismissal will pose a challenge both to judges and advocates. The challenge will be to make the law more sensitive to the context of a particular employment relationship while maintaining enough certainty to allow parties to contract in an informed manner. In this way, the changes will enable the law to more accurately respond to the reality of contracting long-term employment relationships. Thank you.
Madam Justice McLachlin, how do you think the changes that you describe will affect the way in which courts interpret employment contracts? Do you think employment contracts will be interpreted differently as a result, and if so, how?
Well, I am not in the business of predicting what courts will do simply because I'm not allowed to be. I simply have to do it. And as you know, courts don't comment on what they will do, especially at our level. But so I'll answer it a generality that and that takes back to the comment I made at the beginning of my remarks that I think courts are concerned there may be a slight move away from the laissez-faire individualist look after yourself approach to the interpretation of contracts and a greater concern with ensuring that the interpretation of contracts is generally fair and just, having regard to the expectation of the parties, social expectations, and so on, economic expectations. So in that respect, I think we're part of a greater trend in the law and of contracts generally, and we'll see more sensitivity to that particular, to the particular personal concerns, to the justice concern, if you wish.
Thank you. Your Lordship, you describe how the modern workplace must reflect certain social and moral imperatives and how business has to be flexible to respond in a more competitive environment. Do you see a conflict between these social and economic changes, and how will employment law be able to reconcile that conflict?
Yes, I think there is a conflict, and I think that we must recognize that at the white-collar level, there's no longer a job for life. At the hourly rated employee level, of course, the employment contract is almost invariably a collective bargaining agreement, and it makes its own provision for the the life of the contract and on the circumstances in which it can be terminated. But when you're dealing with persons who are not subject to a collective bargaining agreement and to persons in middle management and above, I think that they have to accept that because of the pressures on management, first of all, to conform to these new changes, I'm talking about equity, pay equity, the pressure to hire minority people, which causes them to reorganize the workplace and to reallocate the jobs. And on the other hand, of course, you've got the outside pressure coming on them through mergers and acquisitions and the need to lay off people or shut down plants. So that I think that these external forces, one being social and another being business-oriented, are going to have a very significant impact on future employment contracts, and it's going to be something that's going to be very difficult really to resolve. On the one hand, management is going to be interested in trying to keep the contract as general as possible so that it will have the opportunity of reallocating and moving the employee around. On the other hand, I think it's in the interest of the employee also to keep the job description reasonably flexible, because otherwise he may find himself with his job made redundant through economic or other social changes over which neither he nor management had any control. So I think this is going to be quite a challenge to persons who are involved in drawing up these employer-employee contracts.
Ladyship, you mentioned the unacceptability of sexual harassment as an illustration of an implied standard to which modern employees must conform. Could you elaborate as to the kind of evidence which would support dismissal in such cases?
Well, I think Mr. Levitt's trying for a ruling in advance again, but
why not?
I will say that the law of sexual harassment, of course, is, some people would say there isn't one, but it certainly has to be developed. We have a phrase that's used in many, many different situations, and so it's difficult to say exactly even what it is. But it strikes me that what is important in these cases, and this is purely a personal observation, is what is appropriate and relevant to the particular employment situation. Now, if a woman looking for work as a fashion model goes into the Ford agency in New York, it may be appropriate to inquire as to her physical measurements, and that will not be sexual harassment. In another context, it would be. And I think the big problem arises where in the workplace, people are subjected to treatment or comments or whatever that has sexual overtones that is totally irrelevant to what they're there for. Women go there to work, and their physical attributes have nothing to do with that in most cases. And so to be met by comments about physical attributes, what some would say be a mild form of harassment, can be unsettling and even be used as a technique to say subtly to a woman, will put you in your place. First and last, you are a woman, which is a sexual being. And I think women in the workplace want to get away from that. They want not to be seen as sexual objects or something like that. They're there to do a job. And so conduct which is inappropriately sexual, which has nothing to do with the job that they're doing, be it jokes, commentary, or a solicitation or whatever, can amount to harassment. So I just from a personal point of view, I would say the first question is this relevant to what's going on in this work situation? Is this sort of comment relevant? Is this sort of behavior relevant? And if the answer is no, I'm not saying that sexual harassment will be made out in every case, but that at least is a starting point. So again, it's difficult to generalize and say this will be and this won't be. You have to look at the context.
Lord, you describe how the courts are paying greater attention to the context of an employment relationship in deciding issues such as just cause or constructive dismissal. In the future, do you expect to see more contract clauses which address these issues? And what about the problem of stale-dated contracts?
Well, I guess once again, this is just part of an ongoing problem, and it seems to be an easy thing to say, well, why don't you simply revise the contracts from year to year to give an appropriate job description when the person is promoted or reallocated. But it's, as a practical matter, these things aren't done. That once you come into a management stream and you're successful in the sense that you're being appreciated by those you work with and those that you report to, there's going to be a general expansion of your duties and of your responsibilities. And it's going to be very difficult to say at any particular point of time that you've gone from a junior clerical position to a senior or middle management administrator. And unless it's a simple question of having very specific job descriptions, which you have in major companies or in the civil service, it's just not practicable to try to anticipate. It's not practical to try to update these things on a continual basis. So once again, I really think that from management's point of view, that they've got to look at the notice provisions and make sure that they're reasonable. But outside of that, I think that the object should be to keep these contracts as general as possible. It's an oversimplification to say, well, you can get around all of these problems, all these court decisions by having good contracts. But I don't think that a contract which is written today is going to necessarily have a great deal of application to something 2 or 3 years down the line. There may be so many changes in the way the company is operating. There may be so many advances made by the employee, or for that matter, he may have suffered illness or some other some problem, so that he really isn't as an effective employee. So once again, I think you've just got to stress flexibility, and that's about as far as I can take it.
Thank you. Madam Justice McLachlin, is there a tension between the need for certainty to allow parties to contract in an informed manner and the need to recognize that particular circumstances may affect a given employment relationship? And how might courts resolve this tension?
Yes, I think that's a lot of what we've been talking about this morning goes to that tension. The fact, as I mentioned, that you enter into a contract at the beginning of a relationship and it has to last, or as Justice Finlayson says, last over a long period of time in many changed circumstances. And again, I don't think I can do much more than repeat what I suggested earlier, that I think, first of all, you have to try to draft a good contract that will try to foresee as best you can what the problems are. And so it means putting quite a bit of attention into the contract. But even with the best will in the world, you may not be able to draft a good contract that foresees everything. You can have contracts that recognize that changed circumstances will come about, and agreement to agree clauses, and we saw the fate of those with the Charlottetown Accord, but that's a device people use in the commercial world. But the fact of the matter is that the contract device just cannot provide a solution for everything that's going to happen 20 years down the line. And so as Justice Finlayson says, I think, first of all, the parties have to be flexible in recognizing what's going on, but the law has to recognize that changes take place and so on. And it does this already through a variety of things. Implied terms, in some of the cases Justice Finlayson was talking about, we saw implied terms being used to say, well, it was an implied term that if you got sick, or it was an implied term if the company did this. And so the courts they're making it up. It's what's reasonable. I mean, these parties didn't think about getting sick, for example, or whatever when they made the contract. But the device of implied terms is quite a legitimate contract device to allow the courts to do what's just in the circumstances. And then there may be other devices in particular cases, like unconscionability, or maybe even a whole new contract implied, or perhaps something along the lines of the doctrine of good faith to which I referred earlier, which may allow the courts to do what is right and just in the changed circumstances. So that puts the element of flexibility, which Mr. Justice Finlayson's been talking about, into the law. Unfortunately, the problem is you lose some certainty. But the certainty of 2 months' notice, for example, where you've been working 25 years, seems like rather hollow justice to many. So it's the same story in this area of the law as so many others. The courts try and strike a balance between a reasonable degree of certainty on the one hand and the ability to do flexible justice on the other.
Would you wish to add anything to that?
No, I think I might end on this note that Madam Justice McLachlin and I have been talking about principles, and of course that means that we've been talking in generalities. I can tell you that as practitioners, that what you have to do in any given case is become very fact specific. You'll observe that in going through these various cases in which there's talked about stale dated contracts, and there's talk about unconscionability, and there's talk about discrimination, things of that nature, the answer in almost all of those cases was to demonstrate on the facts that those concepts didn't apply. And I think that that's what you've got to recognize, that that in every case they're going to be decided on their individual facts, and it's the circumstances of the case which will determine really in the last analysis whether you succeed or fail in either asserting or defending any cause of action for wrongful dismissal. Thank you.
I want to thank both of you for their honor of your presence and for the quality of your presentations on behalf of all of us.